And we'll just go in that order if that's okay with everybody. So, ma'am, I have you registered as Cleo Petricek, representing the Travis County Crime Victims Group, and yourself, and as the co-founder of Save Austin Now and founder of Democrats for a Safe Austin, testifying neutrally today. Is that all correct?
Yes.
All right.
Thank you,
All
Chairman Moody and Vice Chair Cook, and all committee members for all your hard work and long hours on behalf of crime victims. HB17 represents a first step towards ensuring that DAs can't conduct personal social engineering experiments at the expense of society and victims of crime. The bill is flawed, and I'm here today to highlight how the flaws might be corrected. HB17 seeks to prevent DAs from creating special unpunished classes of crime. While its intent is clear, the bill unnecessarily mentions diversionary programs as exceptions and thus creates an unintentional path for a DA to achieve the outcome of not seriously punishing certain crimes. Moreover, the language used in the bill focuses on a formal or stated policy of non-prosecution, which leaves ample room for DAs to pursue strategies of non-prosecution. In short, HB 17 prevents flagrant public statements around non-prosecution, but it does not effectively discourage pursuing many of the same outcomes. A potential remedy for the flaws in HB 17 would be to employ an investigative body capable of considering the balance of evidence involved in a misconduct allegation. An investigative body can consider things such as prosecution rates for classes of crime to determine if there is measurable systemic evidence of misconduct. This is a goal of HB 17, to ensure that no DA can systemically thwart the pursuit of justice simply because they don't like some aspect of the law. Every crime victim deserves to know that their situation will receive unbiased treatment based on evidence, and that personal opinions held by a DA will not influence their pursuit of justice. As a part of Travis County Crime Victims Group, I asked murdered victim families to discuss how HB 17 should be expanded to include an administrative rights of crime victims, including victims have the right to be treated with respect and dignity throughout the criminal justice process. Several victims have submitted comments online for you today. Christina Byington, a family member of murdered victim Anita Byington, stated that throughout her interactions with DA Garza and his office, victims have been treated with the blatant lack of respect and dignity and left in the dark regarding their family member's murder case. Connie Braham, a mother of murdered victim Christopher Branham, stated that under DA Garza, he gave 4 lenient plea deals, including one 14-year plea deal for murder without her family's input and 1 dismissal. DA Garza also violated their family's victim rights, as all plea deals were extended, accepted, and signed without her family given an opportunity to provide victim impact statements. Crime victim rights are constitutional rights, not privileges a DA can simply revoke or ignore. One other thing that Connie would like to see added or amended to the bill was once a DA is removed from their position, they are no longer eligible for re-election. Thank you.
Cleo, thank you very much. I appreciate you taking the time to present your testimony. Members, do you have any questions for Ms. Petricek? No? Okay. Nikki, I have you registered as Nikki Presley, representing Texas Public Policy Foundation, testifying neutrally here today. Is that all correct?
Yes, sir.
Okay. All right. Go ahead.
My name is Nikki Presley. I'm the Texas State Director and Chief of Staff for Right on Crime at the Texas Public Policy Foundation. As Vice Chair Cook already kind of outlined, HB 17 amended the definition of official misconduct to include a prosecuting attorney's adoption or enforcement of a policy of refusing to prosecute a class or type of crime, and then also added additional safeguards to that petition and investigative process. ROC, Right on Crime, supported HB 17 because although we do believe in prosecutorial innovation, there's a difference between an innovative prosecutor and someone who is trying to erode the rule of law. Specifically, we appreciated the language. We believed it had a precise definition of what a non-enforcement policy looks like. It included exceptions for true discretion and diversionary programs, and it enhanced the accountability of prosecutors. I think from what we have seen so far in a couple of the petitions filed, people are able to get into the court and file their petitions, so I think it is working so far. And that pretty much concludes my testimony, unless you would like me to kind of talk about a few other approaches that other states have taken, but sticking to this bill, that concludes my testimony.
I would welcome that.
Okay. So Florida, actually, the governor has the power to remove prosecutors. And Tennessee, the attorney general has the power to petition the Supreme Court for a district attorney to be removed. And the Supreme Court does an investigation. And if they find that they refuse to prosecute, then they can appoint someone pro tem in that in the replacement. And then Georgia also introduced legislation last session to create a commission that would be the investigative body.
And as part of the broader conversation that we had last session, I think there was, I wouldn't say maybe exactly the same as what you just listed from Georgia, but there was a conversation around reconstituting I can't remember the name of the office anymore. It's one of the few things that we've actually sunsetted. Maybe one of the only two things we've ever sunsetted. So it was a discussion that was had, and then so the path that the legislature found forward was HB17 through the Vice Chairman's leadership. And so I do want to say, I think that is something that we weighed in, kind of waded into how to do this. We have a statute on the books that's been there for some time. Is there a way to kind of utilize that process and bring in a certain conduct that was being concerned? The way that I've always talked about it is as providing blanket clemency, right? We all know that power belongs to the governor alone. And so and I think you hit the nail, when you talk about innovation versus subversion, right? Those are two different things. Innovation is something that we expect our elected leaders to engage in, to understand how to best serve their community. We want to foster that. We want to make sure they have the tools available to do that. We certainly want to curtail subversion, right? Those are the two kind of lanes that I think about this in. And so, no, I appreciate your comments, and always good to know what other states are doing. But I think that kind of working within the constructs that we had was the most efficient way forward. Members, do you have any other questions? Yes, Representative Harris.
Thanks, Chair. Hey, thanks, Nikki, for being here. Quick clarifying things. I always do like to learn from the experiences of other states. In the states you mentioned where, one state had the governor can remove a DA, it broadened the category of folks, I guess, petition for the removal. Were they similarly, were the triggers similar to the way HB17 is constructed, as in, like, could a governor, and I don't know if you said Florida, could the governor remove a DA if that DA had, like HB17 does, and forgive me if I'm butchering the language here, has a policy or had a professed, category of crimes for which he wasn't going to punish or prosecute? Was it similar triggers that had to be satisfied for a governor to remove or for other people to petition for removal of a DA, or do they have much more broad discretion?
I believe so. It might have been a little broader, but we also have a Florida state director and a Tennessee state director. So if you'd like, I can definitely meet with them, get a little bit more details, and get back to you.
No urgency, but I'd appreciate the clarification. Thank you.
No, that'd be helpful if you can supply the committee with that information, just as we kind of delve into the conversation. Do we have Representative Bowers? Do you have a question? Yes, ma'am.
Thank you, Mr. Chairman. And thank you, Vice Chair Cook. I want to start by saying thank you for working with me and accepting the amendment during the regular session. The question is for Shannon Edmonds, and so have you
Let me do this first. Do you have a question for the two witnesses that have testified so far?
No.
No. So let me then do. I'm gonna. Let me recognize Shannon, get him on the record if he wants to offer any commentary to begin with, and then I'll re-recognize you to ask questions.
Sure.
Is that okay?
Absolutely.
All right.
Thank you.
So at this time, Chair recognizes Shannon Edmonds, representing the Texas District and County Attorneys Association. and testifying neutrally here today, as usual. Sir, the floor is yours. Is that all correct, first of all?
Thank you, Mr. Chairman. It is correct. Testifying here at the invitation of the committee. I'm happy to answer Representative Bowers'
Okay. let's-
question right
let's
in.
start
Let's
there.
strike while the iron's
Representative
hot.
Well, thank you all, and I really appreciate that, but I'm going to toss it right back to you because I would like to hear your testimony first. I do have a question, but I want to hear what you have to share, if there's anything more.
Certainly, thank you. I cannot improve on the author's description of how what became HB17 was developed and the purpose behind it. That's our understanding of it as well, and the impact that it has had. The only other thing I would add, I think that Vice Chair Cook referenced that there have been some petitions filed. We count 4 petitions for removal filed since HB17 went into effect. One of them was in Hayes County, filed by the local clerk against the DA. That was soon dismissed. Ironically, just last week, that clerk resigned under his own removal lawsuit brought by other people in the community. Because again, yes, local politics is never dull. Because the removal statute in general does apply to all local officials other than judges, essentially. There was also an initial, not long after that was filed and disposed of, there was an initial removal petition filed in Travis County against the DA by a man who was charged with a criminal offense by that office. And one of the wise things that this body did, and I know prosecutors appreciate the author listening to concerns that disgruntled defendants would try to use it against them. So a person charged with a crime cannot file a petition for removal. So that was dismissed. Then a removal petition was filed in Angelina County against a prosecutor. And I haven't seen the pleadings, but my understanding was that that was not actually HB17 related. It just shows you that the original law before the amendment was also in effect. That was a long-standing local political situation. It was summarily dismissed by the outside judge who was brought in to hear it. And then we have the current pending removal petition against the Travis County DA that was described. I also only know what I've read, and what Vice Chair Cook stated is my understanding of the situation as well.
Thank you. And,
Representative Bowers.
for recognizing me, and again, thank you, Vice Chair Cook. I think you answered part of my question, because part of it, the first part of it was, had you gotten any feedback from your DAs, and what was it, how was it playing out since HB17 became law? But I think too, I want to hear from you on cost to implement this law, because I am hearing from my county, my county on cost, but also on data security risk that might be a problem.
Well, when it comes to removals, our members are on both sides of this litigation, right? So if prosecutors being removed by another prosecutor from another jurisdiction. So the way that normally works is the judge will appoint, under the bill, a prosecutor from that regional, that administrative region, and sometimes those prosecutors can incur costs. I think most of them are either able to assume them under their existing budgets, or if not, they can go to their commissioners and ask that they provide for that situation. It wasn't addressed specifically in HB17, but to date, it hasn't been an issue because these cases have been dismissed earlier. It may be interesting to talk to the current Bell County attorney who's handling this current prosecution. I'm sure if he has run into a cost problem on the prosecution side, he can tell you how that may have impacted the handling of that case. The other thing to realize is that when a prosecutor is a subject of removal, it is not required that the county where they are based provide for their defense. So oftentimes prosecutors, if their commissioners will not provide for their defense, must pay for that out of their own private pocket for a lawsuit that arises from doing something in their official capacity. And that is certainly something that I think concerns prosecutors who are subject to some of these removal situations that are mostly just local politics taken to the courthouse. But there is no easy solution to that. It's something that is being discussed among our members, but I don't think at this time they have a proposal to bring forward.
Any other questions? No? Members? Let's see. You answered most of my questions in your testimony. I guess, and we talked a lot, and I know as we worked through this bill, going back to Ms. Presley's point about innovation, right? We have a lot of tools that we want prosecutors to use, and we want to make sure that we created some exceptions, and there's some exceptions in the bill when we talk about pretrial diversion or some other types of programs that are longstanding that we didn't want to kind of wrap up into this particular provision. So I guess my question would be, did we fail or maybe didn't see a potential exception out there that maybe an earnest prosecutor is trying to implement innovation, but we didn't cover it in one of our exceptions? Is there anything that comes to mind on that front?
Well, I know that the prosecutors who worked on the legislation, and we had members who were all over the map on this bill. Some opposed it on principle, some opposed it and worked to improve it and are appreciative of those efforts. Some supported it, but also thought there needed to be some changes, like some of the exceptions that are in there, because they foresaw how it could be misused, not in accordance with the intent of the legislation to and so that's why some of those exceptions are in there. And I haven't had any prosecutors come to me yet and say they would either like that they see a need for additional exceptions or that any are necessarily being abused. Of course, that would be from somebody who's trying to file a petition, I guess. But it is important to realize that, as we've seen with some of these other, anytime you have a removal situation, not just for prosecutors, but you're having locally elected officials and someone is trying to kick them out of office, and that it's ripe for misuse. So I think you have to be smart about making sure it's not abused, because that has a drag on the entire criminal justice system when the county attorney or district attorney is having to focus on and potentially privately defending themselves at great cost against something that is preventing them from doing the job that they were elected to do. So we haven't had any additional suggestions brought to us. I know there was some discussion of, last session, I think House Bill 200 was another piece of legislation to resurrect the old Prosecutor Coordinating Council. One of the differences between Texas and some of the other states that Ms. Presley might have mentioned is that our state constitution says that locally elected officials can only be removed by a district court judge after upon a jury verdict, a unanimous jury verdict. And so you would have to amend the state constitution to do a lot of what some other states do. And in Florida, I think the governor has pretty wide discretion to remove prosecutors. He has done that. And one of those cases is still in litigation in federal court. He removed a prosecutor. That prosecutor filed a civil rights lawsuit on First Amendment grounds, lost at the district court. It went up to the 11th Circuit Court of Appeals, and that court granted that appeal and sent it back to the district court to review again what the governor did in light of First Amendment protections that certain elected officials had. So that is still being litigated. We've avoided that to date by the way that HB17 was couched. And so I don't necessarily anticipate those issues being a problem with HB17, but only time will tell.
I appreciate that. As we go forward, and I think if I could make this request of you, because to Representative Bauer's point about price tag and cost, and there, I mean, it is kind of an interesting position to be in. I know, obviously, our experience in El Paso and the removal of the district attorney there, this was prior to HB17, the county commissioner's court declining to pay the legal fees, I think was, I don't think it was the impetus for her resigning. Now, I think that was the right result in that case. But should cost of defending be the sole driver of the removal of an elected official? That is, it's touchy, because as you said, you've got people that are, got axes to grind in local politics. So we need to be very, I think that's the really tough needle to thread here. And I think that's the good work that the vice chairman did on this is tough needle to thread. You have an elected official, a constitutional official here in Texas that had their long-standing laws on how we go through this process, and how do you thread that needle to make sure that they have the right process. So if there are ideas, thoughts, anything like that that comes out of any of your conversations with your members, and again, I know you had members, and this is partisanship all over the place on this. I mean, if I remember the testimony correctly, and concerns and things that we were trying to kind of ferret out. But if you have some consensus or something that you all would want to provide to us as we go forward in our process, that would be great. And then to the second question that I asked about the exceptions, if you do hear anything, sounds like you haven't heard anything yet, but if that does come up, if there's something out there that you think maybe we missed or needs to be tightened up, I think that would also be helpful to provide. Members, do we have any other? Yes, Vice Chairman.
I would just add that on the attorney's fees issue, Chairman Canales did make an amendment that we did accept that at least gave the court the discretion. If you're found not to have violated official misconduct, then at least you have the ability. The court may award attorney's fees.
Yeah, we have the
Correct.
loser pays provision there. That's right.
Yes, thank you.
Now I'm starting to remember last session.
Blocked it out for a while. And I also wanted to just kind of say to some of your points. I mean, I know, and I'm not saying you, but I know a lot of us sometimes when we get frustrated with something, we have the shotgun approach, and, trying to fix it all. And so I really think what we tried to do with HB17 was more of a narrow, tailored approach. But that's not to say that, I wrote down several of the things that you said, and I think that just because they're not in HB17 doesn't make HB17 a bad bill, nor does it mean that we can't, address those issues. And so I'd be happy to visit with you afterwards on some of the concerns that you gave, because I think they're all, at least two of the things you said I wrote down that I thought were very valid and things that we should work on. So thank you for your testimony.
If I may ask, how do you feel about an investigative body, or how do you feel about adding that to a bill, or that would just need to be refiled to have that as part of a way to, so that there is the discretion and all of these other, not loopholes, but things that district attorneys have the right to do. There is people that are unelected that are able to, or designate how to investigate a prosecutor incompetence.
Yeah, and I appreciate the question, and it's certainly something that we took up as a part of a broader conversation. If I remember correctly, we had a pretty big roundtable conversation. I think Chairman Leach was the author of that particular piece of legislation, and we all got got around the table and started thinking through that. We also had some data to look back at, although it was very difficult because it was years ago that commission existed in Texas. But we went back and looked at it and looked at its budget. And we've heard questions about what does that cost, what does that look like, and the efficiency of having something like that. The policy directive that we took in the 88th session was to move forward with House Bill 17, and kind of left the conversation on the commission by the wayside. This is a body that will continue to consider anything that comes forward, and it's going to, if that's something that comes forward, conversations begin anew about whether that's something to look into. I would say that the body itself, the legislature itself, not just the House, but this was the path that we thought was, that kind of threaded the needle of all of those different issues to see if we could make sure that we were creating a pretty a clear line of what's okay and what's not okay, and also but not not stepping on what is long respected notions of prosecutorial discretion. But we want to make sure that we were being very mindful of all that. But the conversation itself was a good one, and it was broad, and all of these things were talked about even during session. So I appreciate you raising it again. And every session's a new session, and every conversation can begin anew at that point. So I thank you for your time. And I think you did mention that some people had submitted some comments. Yes. Okay, thank you. So, and like I said at the beginning of the hearing, and I would encourage members to do, we did have that portal open for anybody that wanted to submit. It will close when we adjourn today, so if you are racing to get your commentary in, please go ahead and finish that. I'll go real slow before I slam the gavel. But no, thank you for pointing us in that direction so that we know that that's there. Members, do we have any other questions for this panel of witnesses? No? Okay. Well, then I will let you all go about your day.
Thank you.
And I do not have anything else for today. Going back to the beginning of the meeting, for Representative Chasline, Representative Harrison, if you could, if there you have any particular code provisions that you want us to dig into in relation, I think one of them dealt with the bail, kind of bail situation, and the other dealing with, I guess, fraud issues, gender modification, things of that nature. So if there are provisions, please send that to us in my office so that we can take a look at that for future hearings. I would appreciate it. I would also invite